So now let's talk about gifts versus loans. So obviously there are some advantages for each one. So let's walk through in detail, what are those advantages and why do you see certain clients or most clients, picking one or the other? What are some of the kind of most common fact pattern situations that you see?
Yeah, so I would definitely say that we as attorneys prefer gifts because of simplicity. The reason we prefer gifts is especially when an investor has relatives that are handing out money is because it's very simple. You source the family member, you're done. No questions asked. As long as the family member complies with the obligation of filing a gift tax return. In countries like United States, the taxes are paid by donors. And so as long as those compliance requirements are met, which we can go into a bit deeper ahead, gifts are easier source. There's flexibility. The one thing I do caution clients against is gifts from friends. We have had 2 cases in which the government questioned whether it was a legitimate gift or not. And in order to make that story more believable, we had to go back to the investor's relationship with the friend. In this case, we had evidence that they were in high school together and that the friend is a high net worth American citizen and that this was genuinely a gift and there was a gift tax return filed. We tend to shy away from gifts from friends because it fails the common sense test.
Okay, great. All right, so now let's talk about the negatives, the cons. So if you're doing a gift or a loan, what are the disadvantages for each that clients need to be aware of before they pick either one?
Right. I think the biggest issue we see with gifts is the filing of the gift tax return within the United States. When the Tax Cuts and Jobs Act was implemented, the US government basically increased the gift limit tax exemption to 12.92 million, which really helped clients, disclose. Donors say that, hey, I've gifted this 500K or 800K, and it's just making a small dent in my lifetime gift allowance. Now, though, we're going to fall back once the Tax Cuts and Jobs Act expires, and we're going to go back to the old threshold of 5.49 million in gift tax exemption, which is going to make the donors a little bit hesitant, especially if they're high income earners, to file that 708. Anything on top of that as a gift is taxable. So if you're a high net worth individual and you're helping a friend out by giving the gifts, or you're helping a relative out, you might not want to use that 800,000. And we've seen instances where clients have come back and said, my relative did not file the tax return. They're not willing to file it because they do not want to use this exclusion. If the government then requests the gift tax return and you are not able to produce it, that is a basis for rejection. This is what we worry about the most. And we worry about the fact that clients will tell us it's a gift, on paper gift. We've had an instance where the client turned around and returned the money to the relative. And USCIS wanted to understand how. I'll backtrack a little bit. The lender had taken out a home equity line of credit and then used those funds to gift the money to their relative. USCIS came back with an RFE asking to show source of funds of repayment on that HELOC. When we started investigating the HELOC repayment, we noticed that there were transfers from the investor back to the lender. That negates the idea of a gift, and it becomes next to impossible to explain to USCIS why that was happening. So it's very important that if it is gift, it's not a gift in name only, especially if the lender is borrowing against an asset and handing that fund over as gift. So you need to either be in close coordination with the lender and understand what they're doing, how they're repaying those funds, or opt for a loan.
Great, that's really important. Mm-hmm. So now that we kind of have a better idea of advantages, disadvantages for each one, let's dig a little bit more into documentation. So for gifts and loans, what do those backup documents look like that are going to be filed with USCIS and that need to be kind of maintained in case any questions come up years later.
Yes, so for gifts, I think inheritance specifically, the government is very curious and always will ask for a will. If there isn't a will in place, you need to cite local succession rules of intestate succession. For example, in India, most clients will not have a loan. That is because the way the law is written, the funds automatically go to the widowed spouse and the kids, and it's divided equally. If that is the case, there will be documentation available, whether it's on a property. The property will say, hey, this name was entered into the property pursuant to a will, or this name was entered into a property pursuant to intestate succession rules in India. The same thing applies for United States. If there's inheritance, there will be a request for a will. So it's very important to provide that document. One important thing that I like to tell clients is when you're inheriting something like land or cash, government still wants to know how your relative purchased that land or how your relative earned that cash. Sometimes a transaction is so old that those documentation is not available. In that case, we tend to go to relatives that knew the person to get a sworn affidavit from that person attesting that all the income was generated legally. If these are your grandparents, we will ask your parents to write an affidavit. If these are your great-great-grandparents, then it's just going to be secondhand, citing local retention rules, stating, hey, none of these documents are available because they're past retention period. However, my grandfather who's alive is going to write this affidavit. You will also have to provide evidence, again, of the Form 709 gift tax return. Countries like United Arab Emirates, Middle East, where there are no taxes, it is very important to let USCIS know, to educate them so that they do not request tax returns. They do not request copies of the deceased person's tax returns or donor's tax returns. We tend to use articles by PwC, Deloitte, KPMG, top accounting firms to educate the government about the jurisdiction that we're operating in. Taxation is important. Like I said, it's important to make sure that you're abiding by local country tax rules. And then if the transaction is not old, what I mean by old is in the United States, it would have to be within the last 7 years. In India, it would have to be 10 years. Anywhere within the EU, it would be 6 years. If the transactions fall outside of that period, you need to provide a sworn affidavit of the transfer of funds. However, if it's in the last 7 years, then you will have to provide bank statements for both parties, the person who's given the gift and the person who's receiving the gift. Without those documents, if the transaction has occurred in the last 7 years, you cannot get your EB-5 approved. Moving on to loan. Loan in case of a collateralized loan. We see a lot of HELOCs. We see a lot of pledge against securities. Any underlying asset that you pledge in order to borrow funds will have to be sourced. If the purchase is made within the last 7 years or 10 years in India or 6 to 7 years in the rest of the world, you will have to provide your bank statement showing accumulation of that down payment and monthly mortgage payments.
Got it. Okay, that makes a lot of sense. So let's talk about frequently raised concerns. So what are the things clients need to be concerned about if they're doing either a gift or a loan, and some of the most common questions that come up?
Yeah, I think for gifts, the most common question is, can my friend gift me money? And again, I tend to go back to the common sense test of, would the government really believe that your friend gifted you $800,000, right? If there's any doubt in your mind that that would not be an acceptable answer, don't go down that route. So the biggest thing with gifts is tax compliance and documenting the donor source of funds. We get a lot of pushback from the donor when we ask for documents. And in order to alleviate those concerns, we tend to create a Chinese wall between the donor as well as the investor. So what we tend to do is we will have a separate Dropbox account for the donor where they will upload documents. For example, whether it's a will or proof of transfer tax tax or proof of gift tax return, or their bank statements or their tax returns, we will upload that in a separate Dropbox folder, and that portion of the file will be assembled in a separate Dropbox folder. The investor will consent to not looking at those documents and understanding that that is a relationship that the attorney will have with the donor. In case a relative dies without a will, you really have to go back to local country rules to prove to the government that your inheritance was legal. I have the most important suggestion I have for clients is that they should talk to an attorney first before they go project hunting, because a lot of times clients will come to me and they will have no idea what it is to look for. And as an immigration attorney, it is my job to educate my clients, whether the client is willing to take some risk, no risk on immigration front, how to assess a project, how to assess whether the project is fully funded, whether there's immigration risk involved. All these questions can be answered by the immigration attorney that you're working with, and what criteria you need to set when you're evaluating a project. So that is my biggest pointer to clients is, if I were an investor today, my recommendation is find your attorney first, then with the attorney's guidance, start scoping out projects that may work for you. Second suggestion definitely is do not liquidate, do not move money, do not make any moves without talking to an attorney. And final point is, we do get tons of requests for consultations from clients, and we're happy to provide that, but we also tend to have very busy seasons right as the fiscal year ends. So what I mean by that is when October kicks in, October 1st, USCIS's visa quota, DOS's visa quota resets. At that point, H-1B holders, L-1 holders tend to notice that the visa dates aren't proceeding fast enough or aren't moving forward at all. And so they tend to fall back on EB-5. During those months, which is October, November, December, January, it's usually a very busy time. So if clients are looking to kind of file EB-5, I think January, February, March is kind of known to be a lull period where clients will get more attention from attorneys. But as you come closer to the reset of the fiscal year, attorneys are going to be more busy. One suggestion I do have for clients is I'll get questions over email asking legal source of funds related questions. It's very difficult for us to answer those questions over email without understanding your background, without understanding the background of the donor, without understanding where you're looking to borrow funds from. So I think that my recommendation to clients is you reach out to me, try and schedule a 20-minute consult, give me some background so I can then understand what your source is and give you guidance accordingly. Do not send questions on, my mother's giving me a gift, will that work? Well, I wouldn't know the answer to that because I would have to know where your mom's getting the money from. What asset is she liquidating? So it's an in-depth discussion that takes time. So I'd recommend sending a WhatsApp if you're ready to pull the trigger, scheduling that initial consultation, and then getting the ball rolling on the process.
Great. Thank you very much. That was super helpful. And again, if you are interested in exploring an EB-5 investment and getting more information about the source of funds and what your application could look like, please reach out to Anahita. Her WhatsApp and email and website are there on the screen. And for any questions about the projects, about Twin Lakes, the rural EB-5 loan project, or our Boynton Beach multifamily project with the higher investment return, please reach out to us, WhatsApp or email, or visit our website, and we'll be happy to get you more information about any of those projects or other projects that we have open. So with that, thank you again for taking time to listen to the webinar, and we look forward to working with you in the future.